Debt collectors are counting on you to be scared and uninformed, but there are federal laws, right now, that put real limits on what they can do to you. Knowing these laws could save your credit, your paycheck, and your peace of mind. Today, we're covering 3 specific protections: your right to force a debt collector to prove the debt is real, your right to freeze your credit for free, and the fact that in America, owing money is not a crime. Let's get into it. Law number 1. Your right to demand proof of a debt before you pay a single dollar. This is called the debt verification right, and it is one of the most powerful tools you have against collectors. This right comes from the Fair Debt Collection Practices Act, the FDCPA, specifically Section 809. It says that within 30 days of a collector first contacting you, you can send a written request demanding they verify the debt is real and that they have the legal right to collect it. Here is a real situation this happens in. A collections agency calls you about a $1,400 medical bill. You don't recognize it. Maybe it's been sold 3 times to different collectors. You have no idea if this debt is even yours or if the amount is accurate. Once you send that written verification request, the collector must stop all collection activity, no calls, no letters, no credit reporting of the debt, until they send you proof. If they keep collecting after you've requested verification, they've broken federal law and can be sued. Here's exactly what to do. Within 30 days of that first contact, write a letter, physical mail, saying you dispute the debt and are requesting verification. Keep it simple. You don't need a lawyer to write it. Templates are free online. Send it certified mail with return receipt so you have proof they received it. Keep a copy for yourself. Under the FDCPA, if they violate the law after receiving your letter, you can sue them for up to $1,000 in statutory damages, plus your actual damages and attorney fees. If they can't verify the debt, they must stop collecting it entirely. Many collectors can't produce the paperwork, especially on old or resold debts, and they know it. Your letter alone may make them go away. The FDCPA also bans collectors from calling before 8 a.m. or after 9 p.m, using threats or using profane language. If any of that is happening to you, document it. Every violation is a potential lawsuit in your favour. Law number 2. Your right to freeze your credit completely, for free, anytime you want. This means lenders cannot open new credit accounts in your name without your permission. It is one of the strongest identity protections that exists. This comes from the Fair Credit Reporting Act, the FCRA, specifically amended by the Economic Growth Act of 2018. Section 605A gives every American the right to place a security freeze on their credit report at all 3 major bureaus, Equifax, Experian, and TransUnion, at no cost. Here is where this protects you. Say a debt collector or scammer tries to open a new credit card or loan in your name using your personal information. Without a freeze, they can succeed, and you're suddenly on the hook for debt you never agreed to. With a freeze in place, any lender who tries to pull your credit report gets blocked. The account cannot be opened. The FCRA also requires bureaus to place your freeze within 1 business day of an online or phone request, and within 3 days by mail. Go to each bureau's website directly, Equifax.com, Experian.com, and TransUnion.com. Each one has a security freeze section. You'll create a free account, verify your identity, and request the freeze. It takes about 10 minutes per bureau. You'll receive a PIN or password, write it down, and keep it safe. You'll need it to temporarily lift the freeze if you apply for credit yourself. Lifting the freeze is also free and can be done in minutes online. You can also freeze your children's credit. Minors have credit files that can be exploited. Under the FCRA, parents can request a freeze for children under 16. This is free and is something most parents have never heard of. A credit freeze does not hurt your credit score. It does not affect existing accounts. It simply puts a lock on new credit being opened. There is no downside to having one, and the only people inconvenienced by your freeze are people trying to use your identity without permission. Law number 3 is one that debt collectors desperately do not want you to know. In the United States, you cannot be arrested or put in jail simply for owing money. Debt is a civil matter, not a criminal one. You are not a criminal because you have debt. The United States abolished debtors' prisons in 1833. Today, the FDCPA reinforces this by explicitly prohibiting collectors from threatening you with arrest for not paying a debt. Section 807 of the FDCPA lists threatening false legal action as an illegal practice. This is one of the most common illegal tactics used by bad faith collectors. They call and say things like, "If you don't pay today, we will have you arrested," or "A warrant has been issued for your arrest." These are lies, and they are illegal. The only narrow exception is if you've been ordered by a court to appear and you refuse. That's contempt of court, not debt, but simply owing money, not a crime. No warrant, no arrest. Collectors who say otherwise are lying to your face and breaking the law. Threatening arrest to collect a debt is a federal violation of the FDCPA. You can report it to the Consumer Financial Protection Bureau, the CFPB, and to your state attorney general. You can also sue the collector directly for up to $1,000 per violation plus damages. If a collector threatens you with arrest, do not panic. Record it if your state allows one-party consent recording. Either way, write down the date, time, what they said, and the company name. This is your evidence. File a complaint at consumerfinance.gov. That's the CFPB's website. It's free, takes 15 minutes, and the CFPB has authority to investigate and find debt collectors. Many people have received real relief from filing these complaints. You can also find a consumer rights attorney who handles FDCPA cases. Many take these cases on contingency, meaning no money out of your pocket. If you win, the collector pays your attorney fees. You have nothing to lose by at least making a call. Let's bring it all together. First, under the FDCPA Section 809, you have 30 days from first contact to demand written verification of any debt, and all collection must stop until they prove it's real. Second, under FCRA Section 605A, you can freeze your credit at all three bureaus for free in minutes. It blocks new accounts from being opened in your name, and it does not hurt your credit score, not even by 1 point. Third, owing money is not a crime. Debtors' prisons were abolished in 1833, and the FDCPA Section 807 makes it illegal for any collector to threaten you with arrest. If they do, that threat itself is the violation, and you can sue. These three laws exist because Congress recognized that people in debt are vulnerable, and that some collectors will exploit that vulnerability every time they can. The law is already on your side, you just have to know it's there. Follow law in plain sight. Know your rights before someone counts on you not knowing them. We break down real federal laws in plain English every week, so you're never caught off guard again. Share this video with someone who's being pressured by a debt collector right now. The information in this video is free, and it might be exactly what they need to hear today.